Judge, quickly for Peyton, we did put conditions on him previously, and the GPS copy that you ordered initially, it was supposed to be obtained prior to release was 7 to 7.
Yes, Judge. No,
Okay,
just do 9. Okay.
9 to 6?
9 to 6.
Yes, Judge.
Monitor, but he doesn't have them?
He should. Mr. Peyton, do you have the GPS numbers?
You just pulled it out.
We said prior to release.
Yeah, it was supposed to be. Oh, sorry, he was out on bond, and I think the charges got filed, so he was taken and they must have cut it off. Go ahead and have a signature.
You're Ms. Jimenez Alvarado.
Yes, Judge.
Ma'am, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent.
All right, this is a turning point. Miranda rights are being read out loud, which means we've now crossed that line. This isn't just drama anymore. It's the real legal process kicking in. But take a moment, listen to the judge's tone. Hear that? That slight weariness in his voice. That's not just courtroom fatigue. That's history speaking, because chances are, this wild couple has turned this courtroom into a stage before. Now imagine this. You're standing outside, and suddenly someone whacks you with a stick, then jumps in their car, honks non-stop, and drives literal circles around you. Would you call that passion? Or complete madness? Drop your take in the comments. Is this just toxic love gone overboard, or are we watching the unraveling of a full-blown meltdown? Because honestly, if this is love, it sure doesn't look like the kind anyone should be chasing.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
On July 2nd, 2024, officers were dispatched to FSRA at the intersection of Cherry Brook and Cherry. The complainant witness stated during a verbal argument, the defendant struck the complainant witness on his face once with a closed fist, causing pain. The complainant witness then grabbed the defendant in a bear hug before releasing her and went outside to separate himself from her. The defendant followed him outside and struck the complaining witness with a stick about his face and neck several times, causing pain and visible injuries. The complaining witness stated the defendant got into the vehicle and began driving up and down the street, honking the horn at him. And the complaining witness stated that while walking, the defendant turned the vehicle into a driveway and the vehicle came extremely close to him.
Intent to hit?
I'm not sure, but I know, I mean, that's the other allegation, but I think the AFM stems from the stick and the punch.
What is the relation between the two?
They're a common law married, Your Honor.
For what?
They're a common law married.
Prior aggravated assault of a family member, is it the same complainant?
It is not. It is not, Your Honor. In the case, that case has been was dismissed.
I know, but I'm curious to see if it's the same
It
complainant.
is. Yeah, it is.
Oh, I'm sorry. It is my fault.
Yeah.
I don't want you to have contact with this person.
Okay, well,
If debate, no. She's a prior aggravated assault that was dismissed not 4 months ago. And now we're
It's
charged
fine.
with another assault?
Your Honor, it was 9 months ago when the case was dismissed. This case is from July 2nd of 2024. So this case is 8 months old. They were still together. They've been together. As you can see, she's pregnant. He is the father.
Great,
There
so we
is-
have more stress now, you know?
There is another note that says an officer, Dennis Rice, tried to perform an on-scene evidence-based risk assessment to talk to the CW and to risk of there's a lethal assault, and the victim refused. So and the only reason why she knew about this, Judge, is she was in the process of renewing her DACA, and they told her that she may have an open warrant. So she went and checked, and then she hired us. So this case was, filed a while ago, Judge.
What happened in the aggravated assault, please?
Hold up, did you hear that right? The defendant allegedly fired a gun from a moving car during a domestic dispute. That's not just Messier's straight-up aggravated assault with a deadly weapon. This isn't your typical family squabble. This is serious, life-threatening behavior with legal weight behind it. And now, despite all that, she's asking the court for bond. That's a bold move. The real question here is Is the justice system showing careful due process? Or is it turning a blind eye in the name of leniency when someone brings a firearm into a heated argument that changes everything? So what do you think? Is the judge playing it safe or being far too soft? Drop your thoughts below.
What I have here, Judge, is that complainant witness and defendant were in a dating relationship. Defendant came to the complainant witness's work and pointed a gun at him while he was walking out, while she was in her vehicle. While he was on the sidewalk, the defendant fired the gun at him from inside the car.
Shot a gun at it, allegedly? Is that what you're saying?
That's
I don't want you to have contact with this person. I don't care. I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies this person as a protected individual, Mr. Chicas as a protected individual. You cannot commit family violence or assault against this person. Commit an act.
Don't say anything. Don't say anything. Don't say
I
anything.
want you to listen, because if you violate this court order, the state can and probably will file a violation of protective order against you, and that is the capital murder of misdemeanor. Do you understand?
Yes, Judge.
You are not to have any contact with this person. You are not to threaten, harass, use another person to communicate a threat or harassing behavior. He is now listed as a protected individual. You cannot commit an offense in furtherance of section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot be in possession of a gun or go within 200 feet of where he lives or where he works. Do you understand? If you violate this, like I said, the state can and probably will file an additional case against you. And then I, on this case, will revoke your bond. Do you understand?
Yes, Judge.
I will give you a PR bond now, but it's the only one that you're gonna get. If I find that you're a danger to my city, I have only one place. Do you understand?
Yes, Judge.
Just so you know, Your Honor, the CW has a criminal history as well. In fact, I think he was on parole.
Doesn't make me feel better.
Okay, I'm just letting you know. It's
Two people just,
I understand.
there are people who are good for each other, and there are people who aren't so much. When you have cancer, what do? You cut it out, because if you don't, it kills you. There are certain people in life that may be like that as well, you know? Now, a second case. I don't want anything to happen. And so the best prescription is no contact. You're not to be in possession of weapons as well. You're not to consume alcohol or illegal drugs. Do you understand?
Yes, Judge.
You're pretty good at that.
Yeah, you're gonna have to move back. Yeah.
252 5470.
And so, Judge, obviously they.
I'm not, Marcos, it's not absolute, right? I'm not talking forever,
Okay.
but for now, I don't want any contact. Everything is coming to head now, and the last thing I need is something else to happen, more drama, and I just don't want any more dead bodies on the road. That's all.
I understand.
So, because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Adrogi, and he will tell you if and when you have to come back to court. If he tells me he cannot get a hold of you, then I will issue a warrant for your arrest. If you pick up a new case, I will issue a warrant for your arrest. All I'm asking you to do is just behave yourself, don't have any contact, and don't use alcohol or illegal drugs. That's it.
Yes, Judge.
For now, I'm gonna have you sign, oh, wait a second, I need a bond, right? There's no bond that's set? Okay.
I believe so, Judge.
I'll set your bond at 3,500, and I'll grant you a PR bond. You will have to sign a receipt of Victoria. You will get with Felicia for your bond conditions, and after that, you'll be free to go.
Yes, Judge.
Thank you, Judge. Maybe excuse me?
Okay.
Sign
Yes.
them all right now. Mark, Mark Marbles, she can sign them all right now.
Good morning, Ms. Cintron.
Good morning, Judge.
Ma'am, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
This one feels ripped straight from a Hollywood script. A patrol car gets slammed so hard from behind it, ricochets into another vehicle and the officer inside, he has to shatter his own window just to crawl out. Wild enough on its own, but then we find out the driver was a real estate agent who had just left Hooters. Claimed she only had one drink, but the receipt, yeah, it tells a whole different story. Now here's the real dilemma. A streak of terrible luck. Or was it straight up reckless decision-making wrapped in denial? You be the judge. Drop your verdict in the comments. Was it misfortune, poor choices, or a dangerous combo of both?
I think if you can afford one will be appointed to you, ma'am.
Yes, Your Honor. On February 19th, 2025, at approximately 10:24 p.m., officers were dispatched regarding a patrol vehicle that was rear-ended by another vehicle. The patrol unit had heavy damage, leaving the patrol unit disabled. The impact of the defendant's car crashing into the patrol unit caused the unit to be pushed forward and crash into the car that the officer had pulled over on the side of the road for a traffic stop, causing heavy damage to that vehicle as well. The officer was trapped inside his vehicle and had to break the
I
driver's
think
side
I read about this.
window
Yeah.
to exit. Yes, Your Honor. The officer then made contact with the defendant, who was the driver, and helped her out of her motor vehicle. The defendant advised she was coming from Hooters and had consumed one alcoholic beverage, namely a Blue Moon, before the crash happened. Another officer made contact with the on-duty manager at Hooters, who advised that the defendant arrived around 5 p.m. and left around 10 p.m., provided the defendant's bill listing one Blue Moon and one fireball shot. SMSTs were conducted. It was a 6 out of 6 on the HGN, but the walk and turn and the one leg stand were refused. The DIC was read and the defendant refused both breath and blood. A blood warrant was signed. There is an aggravated assault with a deadly weapon
How
on the
is
same
he-
transaction
Is that
because of the car accident.
because of the car accident?
So may I add a little bit to that, Judge?
Sorry?
May I add something to that, Judge? Judge, she was at the Hooters. There was some people there trying to get some real estate business going. She's a real estate agent. And as she's coming, she left and she's getting onto the freeway. She goes by there all the time. And she's entering the freeway, Highway 59 going north. She was entering and the police officer had stopped someone right there. I mean, it's right at the entrance. And I'm arguing upstairs that the police officer maybe should have moved up a little further up, not right at the entrance. She's trying to get in. She's looking to her left, the incoming traffic, and she hit the police officer on the right side. It wasn't like it was just, she got him from the right side of her vehicle. But, you know, it is what it is, Judge. I'm dealing with it upstairs, but.
I'm happy to entertain that in a suppression if you want. But right now, this is just probable cause, and I have to give them time to, craft arguments for them. So,
I'm not arguing the DWI judge. I don't even know what the blood test is right now.
we'll wait. Right.
We'll wait. But I'm
So-
upstairs. I don't want it to sound so bad to her because there was some contribution of some kind of negligence.
Again,
And
I understand.
Thank you, Judge. Thank you so much.
Absolutely, of course. So, have you run her license?
We have, it's eligible.
Okay, Ms. Cintron, I'm going to find that there's probable cause to go forward with the case. Can you run her, see if she has any prior DWIs, please? NCIC. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into jail. That's it. Do you understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have either, you may not drive, and that is a part of your bond condition as well. Do you understand?
Yes, Judge.
She doesn't have any history.
Okay, so because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Cervantes, and he will tell you if and when you have to come back to court. If he tells me that you've gone AWOL, that he can't get a hold of you, likewise, I will, revoke your bond. Just stay out of trouble. Don't use, and especially don't pick up any new cases. Keep my community safe. That's all I'm asking. You understand?
I understand, Judge.
Okay, I'm gonna have you sign a release. Victoria will get with Felicia for your bond conditions, and after that, you guys are free to go.
I have one other thing, Judge. I don't know what the court can do about it. They've impounded her car at the towing place, and she has her laptop that she has all her contracts, her real estate business. She has, software for contracts, deeds of trust, and after.
Would you be opposed to getting laptop and things of that nature?
Don't let her get it. She had her
File a
purse.
motion to return.
I'll do that. I'll
File it. I'll entertain it.
Very well. I'll do that. I'll have something on you.
Just give a copy to state so that they can see it. with whether they have any opposition or not, we'll have a hearing and then, soon as we do it. Right.
We'll get it done, Judge.
I'd like to be.
Yeah, well, of course. Right. So just serve everyone and then,
Wait, what? Thank you, Judge.
all right, please.